Litigation finance is an interesting topic for a myriad of reasons. Some states such as California, Texas, and New York allow for the practice, while others limit it for three reasons. The doctrine of Champerty is the first barrier. The concept of Champerty stems from ancient Rome and Greece and is defined as the splitting of fees between the litigating party and a non-party who funds or supports the lawsuit. The doctrine of maintenance, the second barrier to entry, is the injection of a third party who wields undue influence on a case. The third barrier to entry stems from the ABA model rules of professional responsibility. Specifically, Rule 5.4 provides that a lawyer or firm may not share fees with a non-lawyer. All of these doctrines provide an argument against litigation financing and culminate to the possibility that it could eventually lead to an increase in frivolous lawsuits. While this may happen, it is incredibly unlikely because litigation financing is non-recourse. As such, firms must closely examine the different probabilities of each case to decide whether or not it is worth financing. Also, as stated above, many states agree with this sentiment. Lastly, the case must yield a high enough return, and have a high enough possibility of a successful outcome. Generally, a litigation financer will not invest if the expected probability of winning is less than 60%, and the return is high enough to receive a generous profit of 25%. Most financiers will undergo an incredible amount of due diligence before agreeing to finance a case. Sometimes spending as much as six figures to make sure that a lawsuit is meritorious. Though the future is unclear for litigation finance, the future looks promising. With many financiers popping up around the world, financing will be made more accessible to the general public. Is this the future of the practice of law?